Welcome to our Data Privacy Governance webinar. We're glad that you joined, and we hope to have a webinar that's helpful and that you walk away knowing more than you started today and more able to navigate the nuances of both HB 491 in 2024 and HB 444 in 2025. Just a few housekeeping items. If you are on and would like to receive CLE credits, I will need your name and bar number and also your email, and please put that in the chat. If you are watching the webinar later, you can submit your name and bar number to my email, jtingey@ulct.utah.gov. And if you are late and trying to satisfy your ethics or professional training credits, you will have to find those elsewhere because that will not be this. So with that, I have a few disclaimers that I would like to start with. The first being, I work for the Utah League of Cities and Towns. I do not work for the state legislature. I am not a legislator, and I am a negotiator, however, on that legislation. I update league members on the good, bad, and the ugly. And lastly, in 442 BC, Sophocles, if I said that right, once included in one of his plays the following phrase, "No man delights in the bearer of bad news." In other words, this is interpreted by "don't shoot the messenger." And according to all the research that I've been able to do, in 442 BC being the first time that this was brought up, Shakespeare brought it up again in 1598 in his play Henry IV, and it has shot up ever since. Today, that is, it is not more relevant and useful than today during this presentation. Don't shoot the messenger. But hopefully you come away with ideas of implementation and helpful information. As I've discussed with the Office of Data Privacy, they have indicated to me that this is an evolution of what the data privacy will be. In 2024, it was HB 491 as kind of the beginning of the changes in data privacy. And then in 2025, HB 444. The legislation is not perfect. That was acknowledged by the Office of Data Privacy, as well as the drafters in that office that helped draft that language. And that it will take many more years to help government entities to get where they should be with data privacy. In other words, as I've told my own son, do your best and forget the rest. Future legislation will be modifying some of the clunkiness, the gaps, and frankly, the conflicts with other laws like GRAMA and other laws related to transparency and privacy. So be patient is what I'm told with the Office of Data Privacy, and the League will do its best to take input from you and advocate for your interests as it relates to privacy and transparency. So in discussing what went into each of these bills, only a quarter of 491 and 444, I would say, well, I should say this. In HB 444, about 25% was new language. I would say 35% was not applicable to municipalities. 15% came from the Government Internet Information Protection Act, and 25% is estimated to come from GRAMA. So there's a lot of overlap with other current laws and prior laws that have been repealed that were added into the Government Data Privacy Act. The reason why I say that is it may be easy to say, well, this is huge, this is a lot of new stuff, and while there is new stuff, there is a lot that either is not applicable to cities and towns or that came from other laws. So giving you a roadmap on where we're going to go today, we're going to talk about designating your CAO and records officers and their responsibilities, collecting data and providing privacy notice, the data privacy program and the report, along with extensions and exemptions to that report and program, any contractor requirements, training requirements, any requests to amend or correct information that you've received, enforcement for noncompliance, municipal representatives that are selected by the state auditor, and additional privacy resources. And I see a few comments in the chat. They may be, or I see comments being left in the chat. We will, if you do have any questions or concerns, we would love to see those in the chat, but we will answer those at the very end of the webinar, and also ask a few questions from you at the very end. So I just wanted to make sure that you know I'm not just skipping over your questions and concerns, but that they will be answered at the end. So the first thing that must be done is designating your Chief Administrative Officer. Now, all of us, I think, have naturally, we think of Chief Administrative Officer, well, that's already been designated. That is our city manager, that is the operations person within the city. Well, I've been told many times, and this is, again, one of the gaps or the conflicts between different laws, is that this Chief Administrative Officer designation is not actually your CAO as you know it. It is, say, a records CAO. And so that individual needs to be identified. Now, it could be the same as your Chief Administrative Officer, but it doesn't have to be. I know those terms are overlapping, and that will be one of the things that will be fixed this upcoming session. You also, the Chief Administrative Officer duties include designating who the records officers are, ensuring that employees who do receive records requests are getting the training that they need, and that training usually can be done through the state archives and other avenues that you can have them. I'm sure records officers already know where to go to be certified, but that is a good place to start. They have to create the new privacy program report that is now required under the Government Data Privacy Act. There's also a list of things that have to be reported to the state archives. And basically the only new one for 2025 is the last one there. The names of your Chief Administrative Officer and records officers. The Office of Data Privacy and the state archives are creating a easy way to report those. And in fact, I looked this morning, and they've already got a lot of that set up. So a lot of this may already be familiar to you, and the roles that you have to report anyways as a records officer. So those are some of the things that you've got to report to the state archives that are really a lot of them you already had to report. The next one is designating your records officer. Theirs is pretty simple as far as duties go. The care, maintain, use, schedule, dispose, classify, designate, pretty much anything to do with records, that is their duty. And making sure that they're following the laws and moving forward with that. I failed to mention that in the bottom left corner, for anyone that wants to go to specific references of where those duties or any other slide information is found within the code, I've included that below. I've also included on several different slides a website that you can go to that is helpful, or other resources. So hopefully that is helpful to you as you review this. If you do decide to review this again, it will be there for your information. A few items before we talk about the noticing and the content of that. There are a few restrictions on the information that cities and towns can collect. The first being they must only obtain and process that minimum amount of that personal data that is reasonably necessary to provide the service that you're trying to provide. Now that does quite a few things actually. That reduces the type of data that we collect, and therefore it is easier for us to be able to remove some of that information that we otherwise would have had to review under GRAMA in a GRAMA request that no longer we need to do because we don't even have that information. And we're not receiving information that would be a type of data that we would need to give more notice or a different notice. Those are just being eliminated. So just make sure that you're only collecting the data that you need to accomplish the purpose that you're trying to collect it for. The second is you can't establish, maintain, or use undisclosed or covert surveillance of individuals unless it's permitted by law. The same goes with selling or sharing personal data. That has to be required by law. Now, many of you may ask, well, what's the definition of covert surveillance? And that is a great question, one that on all of those, unless permitted by law, that's one of the areas that we as the league want to clarify in future sessions, so that we don't end up in hot water not understanding that we thought that we could do this under the law. Well, what do you mean by unless expressly required by law? And what does covert surveillance mean? And we'll talk a little bit about the public safety exceptions later on in this webinar. But I just want to point that out to you, that there are different limitations with the information that we collect that you need to be careful of when you do collect or sell or share. Going on to the notice provision. So information that would be obtained that is considered public information, all you need as far as the notice content is concerned is a statement indicating that, hey, your information may be available to the public, and that's all you need to give as far as the notice content is concerned. And we'll talk about how that notice is conveyed in the next two slides here. If it is private, protected, or controlled, again, these things were generally in GRAMA noticing already, and I'm not going to read each of those, but a lot of those, as noticed here, I wanted to bring up the fact that a lot of these, as I've color-coded, are straight from GRAMA into GDPA. Now, there are some differences, and admittedly, two of those changes may impact cities and towns to a great degree. and we'll talk about how that's going to impact your city and town. But as far as the language is concerned, the language generally is the same, and there are a few differences as it relates to public records as well as protected records. As you can see in GRAMA, that notice only pertains to a private or a controlled record, whereas GDPA now expands that to notices being given based upon a public record or a protected record, which obviously expands the nature and the breadth of what notice you're being required to do. There are practical things that I'll discuss a little bit later of how you may be able to handle this larger noticing requirement in a more practical way, albeit still a lift by many cities and towns. The three methods of noticing. So this is how you convey that notice to others. One, it has to be in a prominent place where you collect the personal information. Two, on the document or form that the city collects. Or now under GDPA, that expands the ability for any type of classification to use a link or a QR code that links to an electronic version of the privacy notice. This is kind of where I want to lead you, that I feel, just as a suggestion or recommendation, may be helpful, is coming up with a privacy policy that covers every single type of information you collect. I know that's a huge, huge list, but if you can identify what those are and put those into a privacy policy that's online, then at that point, you will either include a link below to that privacy policy online or a QR code on that form. Now, I recognize that there are an enormous amount of forms that you use. We do have some time to be able to get up to speed on putting that link on our forms or QR code. So that gives you an idea of what I would suggest you do moving forward. This, I just wanted to point out again that sometimes we see laws and we think that they are way different and a lot more. Well, these are different ways that are provided under GRAMA, the yellow, and you'll see that's been moved over. The green language, that's been moved over to the GDPA, the Government Data Privacy Act. The last one is, like I talked about, the last edition. So moving on to, as I said, there were three with one exception, and that is the public safety exception as far as the method you are going to use or can use as it relates to public safety issues. If the information or the processing activity serves a public safety interest, and when weighing the benefit between of notice up front and a potential impact on the individual's privacy interest, when weighing that, it weighs toward this allowance or this exception for noticing method, then you can use this noticing method. Different examples that have been included here, giving emergency services, law enforcement, body cam, security camera monitoring, 911 emergency communications. All of those, all you have to do is post that privacy notice on a government website or a public notice website. Now, the purpose really behind that was we don't want to advertise things that would be security related that that we would have to give notice ahead of time saying we are getting your information and this is going to be classified in this series, and go through that. All you need to do is post on the privacy notice, these are the things that we collect as a form of as a method of providing you public safety, and this is our notice, and leave it at that. Again, this could be included within what I already said is that huge privacy notice on your government website. So that gives you an idea of that public safety exception. One item on this, the security camera monitoring, well, two, and the law enforcement body cam or dash cam recordings very well could be considered covert surveillance. That definition of covert surveillance or undisclosed monitoring has not been defined, and that is one thing that we as a league will be moving forward with during the interim in trying to understand how cities can still carry out their public safety services, receive that information, what's required and what's allowed to receive as security camera monitoring. There was other legislation talking about automatic license plate readers and what that does and how that plays into all of those discussions related to covert surveillance. Will be a topic that the Office of Data Privacy and the League goes over. And I should say this, and I didn't mention this before, but the Office of Data Privacy has been extremely helpful and willing to look at the different ways that these things affect cities and towns, and trying to come up with a mechanism to take care of some of those concerns that I'm sure you have right now. And again, we're moving toward year after year, moving towards something that works for all the parties while still providing that privacy protection that many of the public want to keep their information contained if it's able to be contained, and they want that notice. So again, we're still working with them on updating that. Let's move to the website privacy notice. Now this is a little bit different than what I just talked about, which is personal data. This is more so related to user data. And that is any information about a user that is automatically collected by a government website when a user just gets on your website. And this section came from the now repealed Government Internet Information Privacy Act. If you try to go and find these sections, they have been moved over to the GDPA and have been incorporated there. And so all of these really were already required under past versions of the GIPA. So these were already as a part of in fact, I'll show you right here. This gives you an idea of what was there before the repeal portion and how that's been transferred over. Now, as you can see, the gray is new material, new language that's been added, and that F on the bottom of the GIP on the left there has not been added back in this portion of the GDPA. And so just wanted to bring that to your attention. So letting you know that a lot of this is not new. Here are the additions we've got to provide a method of how a user can file a complaint with the Data Privacy Ombudsman or ombudsperson, and how an at-risk employee can request to have their personal information classified as a private record under GRAMA. The second thing that we have to do now is identify what the tracking technology that you use to collect the data. I think your IT individual will know that more than anybody else. So please ask them what that might look like. The third, you have to identify the classes of people. I still don't know what that means, and the different government entities that you share or sell the data to. And then lastly, the record series that the user data is included in. So those are the additional aspects. Now again, I'm going back to what I said before as far as a recommendation, right or wrong, that I think that it would be good to have these things and these items put into that big privacy policy on your website, if you have a website, I guess. And so that is, again, something to consider. There are really, I should say, budding helpful information in its infancy on the Office of Data Privacy website of what a privacy notice might look like, and the different forms that might be, as well as the forms. Now, these are still in draft form, still being developed and used as templates, a starting point for you. So hopefully that will be a good starting point to start from. The next part of this is, I'm sure, what you've all been waiting for, the data privacy policy. Before we hop into the contents of what have to be in that, I think it's important to understand what a processing activity is. And as long as this is, as boring as this is, I'm going to read this because it's important to know later on in the process what this data privacy program report actually has to look like. So it's any operation or set of operations performed on personal data, including collection, recording, organization, structuring, storage, adapting, alteration, access, retrieval, consultation, use, disclosure by transmission, transfer, dissemination, alignment, combination, restriction, erasure, or destruction. Whew, that's a lot there. Pretty much dealing with any processes you've set up to handle personal data and personal information. It's also important to know, because this is going to be a part of this, what a new and what an old processing activity are. The way I understand it is, as I've discussed with the Office of Data Privacy, if you've got a process that you've been using to, say, take in information on a form, it's not a new form prior to, but it's a form that you've used prior to May 7th, 2025, that would be a old processing activity. That is not a new processing activity. But if there is a new form that you create that now collects information that you would need to give notice to, that form will need to have one of those three methods of notification. A prominent place that it's posted, on the actual document or form, the actual statement or what the notice is, and third, what the or a QR code or a link to that online privacy policy. So that is what I would consider a new versus an old processing activity. This is something that I will likely be discussing with the Office of Data Privacy as far as to help cities and towns understand, what am I required to change by 2027, which is the time that we have to change old processing activities, and what is required to change before then, before December 31st, saying that we've complied, and so that is kind of what one of the things that I plan on going over with the Office of Data Privacy. Now, here is something to, again, keep in mind about the requirement to initiate the privacy program before December 31st of this year. And that is, there is a part in the code, in the GDPR, that currently says a government entity that fulfills the reporting requirements satisfies the requirements if they take care of the privacy report, the program report, and then they have technically met that requirement to initiate a privacy program. This likely won't be there next year, because at that point you've already initiated a privacy program, and at that point it's then determining how you are moving forward and refining your private processing activities to better comply with the requirements here. The Data Privacy Program Report, the content of that, you have to identify whether the municipality has initiated the program. Now, obviously, if you've filled out this plan, then you have initiated the program, as what I've just said. It has to identify the privacy practices used by the municipality, currently non-compliant activities, and strategies of how to improve your city and town's privacy program and practices, and then any high-risk processing activities. Now, what is that? That would be anything that would have a significant impact on a person's individual privacy, is how it's defined. Now, how do you determine what is a significant impact on a person's privacy? There's certain factors that they're in code that you need to consider. For example, the sensitivity of the personal data processed, the amount of personal data being processed, the individual's ability to consent to the processing of personal data, and also the risks of unauthorized access or use. If that data is breached, then what is that impact? Is that a big impact? How much does that affect that individual? So different examples of high-risk processing activities include facial recognition, technology, automated decision-making, profiling, genetic data, biometric data, or geolocation data. These, again, would likely all come under the auspices of public safety interests. So this is something that we'll be discussing with the Office of Data Privacy during the interim and the legislative session, how we can better clarify, again, those covert surveillance, how public safety interacts with those high-risk processing activities, and what we could get into hot water with if we're doing unknowingly through the state privacy auditor. So that is something that we'll be going over. The plan must also include information like the types of personal data shared, sold, or purchased, and the legal basis that you have for doing so, the category of individuals or entities that you have sold, shared, or purchased with, including any other governmental entities. And the last part is all of the employees that must take the data privacy training, and I'll get to that, who that is. But you've got to include a percentage of all those individuals that have basically your compliance rate. How many individuals do you have? Okay, how many have taken that and complied with the law? And we'll get into what that percentage looks like and means in another slide a little later. There are a few important points, though, that you should be aware. And here's the first. The privacy report does not need to be submitted to any state agency, but it can be requested by the Office of Data Privacy or Privacy Auditor. As I've talked to those in the Office of Data Privacy, more than anything, and I think it's very sincere, they are there to help move the city forward. Each city is very different in their current status of complying with laws that are under GRAMA, the noticing requirements that are now in GDPA, and some towns have one individual that is the mayor and takes care of essentially many different staff duties that simply there's no employees within that town to provide those services. And so they are the one and only individual providing snow plowing, providing other administrative duties. And so how we take that town and compare it to a Salt Lake City or Ogden, Provo, West Jordan, the top population cities, large cities, wouldn't be right. And so the office has said, look, start where you're at and move forward. So in your privacy plan here, I think it's really important to fill it out, make sure that you are filling it out completely so that you have a basis to move forward. And I can guarantee you that you will be asked for that plan by or after December 31st, when that compliance date is. There is an ability to apply for an exemption or an extension to any specific requirements under the GDPA. I see this most likely coming up in the form of deadlines, whether that be the privacy plan at the end of this year, or December 31st of 2026, or when those non-compliant processes have to be fixed. And so I see those coming up then. Again, I think that office is trying to work with cities and towns the best it can. And there may be a situation that would justify. Under the application, you have to identify what duty and what code citation you are trying to be exempted or receive an extension on, and that justification behind that. Now, keep in mind that application and also the approval of that extension or exemption is reported to the Utah Privacy Governing Board, as well as the state privacy auditor. So be aware of that when you apply for that and are approved for an exemption or extension, that will be given to other individuals as they look at different privacy policies for the state. The next one is a contractor requirement. All the contractors, and this is one that we push back on pretty hard and that we're still working with and negotiating the terms of what this is going to look like going forward, especially after July 1, 2026. But as of now, contractors are required to follow all of the GDPR requirements except having to take the data privacy training. However, after July 2026, we as cities and towns will be held responsible to have in each of our new or renewed contracts a provision that states that the contractor must abide by the GDPR. And I can see this, I can really see this killing a lot of contracts and having contractors walk away because they're not willing to abide by, especially bigger companies and companies that can say, well, you either like it or you either like it or leave it. It's up to you. And at that point, a city or town doesn't have much choice. So again, this is something that we're advocating for, is relooking at this. It's the Office of Data Privacy is exploring the idea of making those contractors that are used by cities and towns on a more regular basis being a state negotiated contract with better terms as far as cost goes, but including that GDPR requirement that they also are required after July 1, 2026. So to be determined on that, and we'll see where that goes. The training requirements. Now, I mentioned you will need to give a percentage of all those that have completed this requirement. The training is actually created by the Office of Data Privacy. However, there is an exception that if you do want to create a privacy training, you can do that and have that be your data privacy training, but it has to include all of the same content that the training provided by the Office of Data Privacy has created. So just be aware of that. All employees who have access to personal data as part of the employee's work duties, or a supervisor who supervises someone that has access to personal data, has to take the training. Any new employees have to complete it within 30 days. If you've already been there, or employees that have worked there at your city or town, they have to take it at least one time per year. So that is the requirements on the training. Let's talk a little bit about request to amend. This is although it's already a part of GDPR as of 2025. So this did not change in 2025 under HB 444. But I wanted to make you aware of this, that there is a provision that says any conflicting provision with GDPR, the more specific or restrictive law will control. As you can see, there is what I would say a more restrictive law in GRAMA as far as what requesters' rights, what rights they have to amend or correct, or the ability to provide a statement saying this is the correct way that this record should be handled, and that has to be attached to that record anytime that record goes out. So that's under GRAMA already. GDPR requires all governmental entities to provide a process that the individual can request or amend or correct personal data furnished to the governmental entity. But there's no specific requirement of a governmental entity to actually amend the record once requested. There's just, you have to set up a procedure. Now, it does say in GDPA that the procedure must still follow other laws. Now, that's presumably also the more specific or restrictive law of grandma. However, this is another, I feel like a broken record here, but this is another area that we are reviewing and looking at to see. In fact, it was one of the trainings that the Office of Data Privacy wanted me to speak on, along with two others, as far as whether it makes sense to redact everything out of grandma and just have it in GDPA as the primary housing portion of what happens when there's a request to amend. There is an additional notice of data breach that was included in 2025, and that is if it is a public record, there is no need to give an individual notice that their information, even though it's public, has been breached. However, you still need to post a notice in a prominent way on your government website. I am still not sure the purpose and reason behind having notice being given for a data breach of public records when they are public, particularly given that we don't need to give public notice when we give out individuals information that's public through a grandma request. We don't call up the one that's provided the information if it's public and say, hey, by the way, your information is being given out by us. And that essentially is the same thing. Someone is getting public information. So we're going to look at that a little bit more, see if we can talk to the Office of Data Privacy to see if there's a way to move forward with some change to this. We tried on this last time and it did not, there wasn't a lot of appetite to change this provision. So we'll see where we go with this. As it relates to enforcement for noncompliance, ultimately this is a process. The Privacy Board instructs the privacy auditor to investigate any violations or alleged violations and then the auditor gives the city, if there is an actual violation that's been validated, we are given 30 days to cure. And if we still fail to cure, the violation is then referred to the Attorney General, and they can either file or not file an action to enjoin or require compliance of a specific law. Now there are I put below there some similarities and differences with what is required under grandma as far as enforcement of noncompliance. In that situation, there are, as you know, criminal penalties in some situations for violations, attorney's fees and costs, etc. And also there, in both grandma and in GDPA, there is a provision talking about the ability to discipline employees that have intentionally violated the GDPA, and grandma. So that's really the same. It's been transferred over. There is now a privacy ombudsperson. Their duties are to serve as a resource. They can mediate data privacy disputes at the request of a governmental entity or an individual. They can raise issues and questions to the governing board regarding serious and repeated violations of data privacy from either a specific entity or, generally speaking, a lot of different entities, widespread. And And then after consultation with the Chief Privacy Officer, they can post on the office's website a summary of the complaint and the resolution. There are a few things to consider here. On the one hand, you've got a mediator that is supposed to act as a independent, impartial individual that can take care of issues and questions, and that's the hope. The hope is that these complaints and problems are going to be resolved, hopefully through mediation. But there's a reporting and a enforcement portion of these duties that in some effect are difficult to match with an impartial view. So we're going to explore that this upcoming session to see whether we can identify different, relook at the duties of the privacy ombudsperson. Just to give you an idea of who that is, that's Lena Taylor. And here's some other who's who in data privacy. Chris Bramwell and Micah Vorwaller and Shane Paul, they have been extremely helpful and very willing to work with and negotiate and try to come to a solution. So I want to give them that credit. You know, it's not always easy to negotiate, but with them, I think that they understand the difficulties that rural cities and all cities ultimately have in moving the ticker forward as it relates to privacy. There are some additional resources that I've included, and you can look at that a little later. We will be sending out this slideshow. So again, it's a work in progress. As you can see, they're going to get to HB 4,323. I have confidence in the state legislature to do that. They said that they need more bills, and so hopefully we can get to that point. Okay, so now that is my presentation, and now I wanted to take care of a few of the questions to see if we can knock some of those out. Thank you for submitting your name and bar number and email. I will put those down. Let me just scroll down here. Yes, the slides will be made available as well as this recording. Okay, John Brems asked, what is a record series and does it require classification prior to a grammar request? Currently, the record series is it's set by the well, it's submitted to the state archives for approval, but the city comes up with a record series saying this type of data that we collect, police intake forms, that's one record series. And that's one thing that they've noticed as the state archives have looked at there are many different record series between different cities and within the same city. And so that's one of their thoughts, is to reduce those down and make those record series, those types and groups of information that have certain retention schedules associated with that have a classification, and does it require classification prior to a grammar request? That designation, as far as classifying, does not need to be done prior to a grammar request. Um, hopefully that answers your question, John. Let me see if I can keep scrolling down here. And if I miss anything here, please. I'm happy to answer questions later on and reach out to you. Thank you, Chris. Chris Bramwell is from the Utah Office of Data Privacy, is actually on this webinar, and he mentioned in the chat that they are working on a generally applicable notice template that entities could use. The template includes the generally accepted purposes for which personal data would be used for most governmental entity services. So that's very helpful. Thank you, Chris. He also mentioned that they offer access to scanning and reporting tools to identify and remediate website tracking technologies on entity websites, such as cookies and tracking tags. And he's included those links within the chat box. Okay, does the Privacy Office also offer services or tools to automatically discover and classify data that entities may have? It looks like they're working on automatic data discovery and classification tool. If our entity is making one of our forms an electronic form, but it captures the same information, would that be considered a new or old processing activity? Great question. I would say that it is a new activity. Even though it collects the same data, it is being collected in a different way. And so if that is the case, I think that that would be considered a new processing activity instead of an old one, even though it covers the same information. Now, obviously, with that, I always let people know if they've got questions. I'm not their attorney, but they're welcome to ask their own attorney. In the new, this is from hopefully I say this right, Laura Magnus. In the new Utah privacy policy law, are we required to disclose within our privacy policy that we share personal information internally between departments or divisions of the same agency? For example, sharing utility billing, emails with communications, or business licensing information with communications. So those, I have discussed that question, and I think that the idea is that those that don't need that information shouldn't receive that information. But those that do need that information, can receive that information without having that in the privacy plan. That being said, I think that it would be fair to put in your privacy plan, and it wouldn't take a whole lot, to say we share this information internally between these departments, and I think that it can be as simple as that. Again, ask your own attorney whether they have the same interpretation that I do. Where do we find the data privacy training required for city employees? That should be on the, if you go to, and I included this in one of the, let me see, one of the early, sorry to make you dizzy there, one of the early slides has that's the privacy policy. If you go onto the Office of Data Privacy, website, there's a tab that says government entities, and it actually has a lot of really good information and guidance, so that it makes it easier on all of us. So that is where you will find the privacy training. A lot of this is, again, in its infancy, and still they're working through a lot of the templates to help different cities and towns and governmental entities. So that would be my answer to that question. Oh, thank you, Laura. There it is. We don't collect electronic data on our website, but we do have PDFs that people print out and submit. What if they scan it and email it to us? Is this considered electronic collection? So I think that it would be considered electronic collection, but I'm not sure the ultimate question that you're having. If you're saying, is that a new or an old processing activity, I would say it depends on what you've done in the past. And if you've done that in the past, then it wouldn't be a new processing activity. It would be an old one. And you would need to just identify that in your plan that this is how we've done it, and we don't have that privacy policy on that PDF or a link or a QR code. And this is one thing that we're going to work on to move forward in our city or town. So hopefully that is helpful. We're at 103 right now. One last question. I see Jake Summers. If you do have any other questions, feel free to reach out to me, jtingey at ulct.utah.gov, or I've put the information again on let's see, where did we go? I don't know if I'm sharing still or not. So we will stop the share. I've got on that a slide all of the information with the different individuals at the Office of Data Privacy that can help you. Oh, good. I was sharing a photo of the elk that I hope to see soon. So, are there any concerns that the inclusion of the contractor PII privacy responsibility is a possible erosion of the governmental immunity shield for unauthorized access to government records and data? On that situation, that is such it's a great question. It's a technical and legal question, one that I don't want to answer here, but happy to have that conversation. If you, Jake, I don't know if you're an attorney or not, but happy to have that discussion offline, and we can go through that. So thank you for joining the webinar, and hopefully we've helped answer those questions and helped you feel more comfortable with moving forward with HB 491 and 444. So appreciate it, and see you all later.